Guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. I am back for part 2, and I love you guys' comments so far today. I want to try to get this out tonight. Of course, this is Monday. Actually, no, it's not Monday. It feels like it's Monday. It's Tuesday, September 2nd. Just got off work about an hour ago and trying to get a few things done. But without further ado, we're going to jump back into this hearing. And again, I do appreciate y'all's comments. And if you haven't subscribed yet to the channel, I would really appreciate it if you would hit that button as well.
Okay. In regards to attorney fees, is having an attorney a choice?
Yes.
Were the dollar amounts that you put in my commissary account considered voluntary?
They were partial payments to you, as we had discussed when you first got in there.
On your pretrial memorandum, they're stated as voluntary.
Objection, there's no question.
How many times that you can recall did I try to inquire about a guardian ad litem with you?
Objection, relevance.
All right, ma'am, can you repeat your question for me?
How many times did I attempt to obtain a guardian ad litem with him?
I'm going to sustain the objection. Next question.
Do you drink?
Yeah.
How often?
Objection, relevance.
What's the relevance of how often Mr. Boone drinks?
Because he's making my, in quotes, drinking problem and blaming a lot of things on what happened to me. And I wanted to find out if he did or did not currently while he had our child.
You want to know whether or not he drank while he had the child?
Yes, if he drinks while he is in the presence of our child.
All right, I'm going to overrule, and I'm not letting this go too far astray. You can answer the question, sir.
I have had a drink in front of our child before.
Okay. Did you have a conversation for a split moment with our son the other day? So you had the understanding when he was asking about the applications that you do not live an hour and 20 or 30 minutes away. You came to the understanding correct that it's only 50 minutes away, 50.
I think it's further than that when I did it on Google Map.
Your Honor, I'm not sure what else I'm supposed to do, so I guess I'm ending whatever part I'm supposed to be doing.
All right. Any redirect? Let me just ask you that.
No.
All right. No redirect. We're going to stand in recess for 10 minutes. We'll come back at 3:20 p.m.
Thank you.
Deputy, do you need a break? Miss Boone, are you there?
I'm here, Your Honor.
Okay. All right. I don't know if I may have accidentally hit mute again. We just located your exhibit that was entered into evidence as Exhibit 1. The clerk now has that. Before we took a break, Petitioner's counsel indicated he did not have any additional questions for Mr. Boone. So now I turn back to petitioner's side and asked, do you have any additional witnesses or evidence you would like the court to consider?
I would call Ms. Boone very briefly.
All right, Mrs. Boone, counsel has some questions for you. And once he is done, what I'll probably do is I'll ask you, do you have anything that you want the court to know right away based on the questions that he has? And then we'll get and see if he has any additional witnesses and evidence, and then I'll turn it over to you for your presentation, okay?
Yes, Your Honor.
All right, you may inquire.
Thank you, Your Honor. Ms. Boone, you filed a financial affidavit in this case on May 30th, 2025. Is that correct?
One moment, please, and I'll pull it. Go ahead with your question while I'm looking for it.
Well, I want you to locate it first because I want to ask specific questions about specific pages. So I'll wait for you to locate it. Did you receive the exhibits that we sent you? Because it also would be in that packet as well.
I have it located.
Okay. And that financial affidavit that you've located, that has a stamp on the top of it that says that it was filed at 1:08 p.m. on May 30th, 2025. Is that correct?
Yes.
Okay. At this time, Your Honor, I'd like to submit what has been previously marked as Petitioner's Exhibit E, which is the respondent's financial affidavit filed on May 30th, 2025, into evidence.
Any objections to the court considering your financial affidavit that was filed May 30th, 2025, Ms. Boone?
No, Your Honor.
All right, hearing no objection, I'll receive into evidence what was pre-marked as E as petitioner's number 3.
Okay, ma'am, I just wanted to ask you a few questions about your affidavit. And I want to just laser focus right in on your expenses section, which starts on your page 6 of the document, and for the court's following of my exhibit, bait stamp page 46. Let me know when you're there, Ms. Boone.
I'm there.
Okay. So this section here is going through what you estimate to be your expenses. The first question I had for you is, have these expenses changed dramatically since you started your incarceration in February of 2020?
They haven't changed because they've never started. It's just an estimate from going off of the canteen list.
Okay. So from February of 2020 until today, you have not actually incurred any of these expenses that you've listed on your financial affidavit. Is that correct?
You're asking me from when I was at Orange County?
Yes.
To the present day.
Yeah, I asked you the question about these expenses, and you said you mentioned something that you haven't actually incurred these expenses yet. So that's what I asked a follow-up question to that of, are you telling me that since you started your incarceration in Orange County in February of 2020 until today, have you actually not incurred any of these expenses that you've listed here on your financial affidavit?
What do you mean by incurred, please?
Have you had to?
She's the smartest person in the room, but she doesn't know what incurred means. Yeah.
To pay them?
Have I had to pay for food? Yes, I have.
Okay. Okay. So has it stayed, though, My first question to you, though, in which you answered it in a different way, so I want to answer it again. Ask you again is, for example, you have here on your financial affidavit that you filed in 2025 that your food expense is $250. My question is, has that number gone dramatically up or gone dramatically down, or has it stayed relatively the same since you started your incarceration in February of 2020?
I don't know or remember in regards to my incarceration 5 years ago, but I know for the current time, this is just an estimate because the prices fluctuate. So as of right now, it's about the same.
Now, does the facility that you're incarcerated in, does it provide you meals for free?
It does.
Okay. Does it provide you breakfast, lunch, and dinner for free?
Yes.
Does it provide you any other meal times other than those 3 times for free? Snack times or anything like that?
No.
Okay. Does it provide you things to drink for free?
Water, yes.
Okay. So when you indicate here that you have an estimated food expense as of May of 2025 of $250, what is that for?
That is for my low blood sugar, which the petitioner is aware that I have ongoing, and need to maintain my blood sugar. My grandfather died of diabetes, and I have to maintain that with snacks and in between meals. Some of the meals are, of course, unappetizing, and my stomach is not able to handle them properly, so I either do without or would fall back on something that I could order or purchase from canteen.
She's very afraid that she might become a diabetic because of her grandfather. And this made me think of, remember during the trial, well, before the trial started, her criminal trial, she was requesting to have snacks available to her in the courthouse. That was a good one, Sarah.
And are you actually incurring this expense in purchasing additional food above and beyond what the prison is offering you for free?
I have from contributions, yes, but on a regular basis, no.
Okay. Explain to me these contributions. What are you talking about when you say from contributions?
I have a friend that will deposit money in my account on a rare instance when she has an extra or something spare.
Okay. Do you have any other contributors?
My brother, when he's able to.
Okay. So if I understand you correctly, this food expense is not for breakfast, lunch, or dinner. It is for supplemental food that you believe is appropriate due to your blood sugar. Is that accurate?
Yes, and also in regards to the meals not being able to be digested properly.
So, so she has one friend. Remember, she had all these friends before the trial. So I guess she's down to one. And whoever this friend is, I hope they're not giving her money when they need it. And God forbid the prison lunch, whatever options that they give you, Sarah, give you indigestion. I mean, that's just horrible, isn't it?
Okay.
Primarily for medical reasons.
And then you have on here another charge of $100, or another expense of $100 for gifts for holidays. Is this for gifts for your son?
Yes, that's under child expenses.
And is this $100, are you asking that Mr. Boone pay you this so that you can give gifts to your son?
Would he be paying the alimony, arrearages, or any dollar amount? Yes, I would like to have that deducted from that dollar amount because I don't have income on a regular basis.
Okay. So you want your husband to give you alimony so that
My
you can...
ex-husband.
You're right, excuse me. You want your ex-husband to continue to give you alimony so that you can then turn around and purchase gifts for your son on your behalf, because you cannot purchase those gifts because you're incarcerated. Is that correct?
My alimony payments can be spent however I make or decide how to do so. And yes, I would like to include my son for gifts on holidays or just because I love it. Yes, that would be a part of my disbursement of my alimony.
Do you think it's fair for Mr. Boone to give you money to purchase gifts for your son that you can't afford to purchase because you're in jail? You think that's fair to him?
Alimony is court order, which
Okay.
is unfair that I have to not be paid what I could have been paid.
Okay.
Yeah. I like his question, though. Do you think it's fair? And he really held restraint there, the attorney, that because you're in prison, that, you should get these sort of options and things. And she's like, of course it is, because, and really she's going, of course, because I'm Sarah Boone. I mean, really, that's how she thinks, obviously, because she deserves whatever. No matter what she's done, she is never wrong. We can call her Sarah Never Wrong Boone.
Also have on here that you have a $200 communication charge. Is that for the phone calls that we've been talking about?
That's for all of the communication opportunities that have not been taken advantage of by the petitioner. It's not just phone calls. It's video visits, videograms, cards. It's a multitudinous amount of technology that is available to be utilized if decided to.
Every effort, every expense that's been incurred. Oh, I'm sorry. You want to finish your point?
No, I was just stating that it is located in my exhibit, so you all are aware of the opportunities and the cost.
Okay. I want to be clear, though. Every expense related to you communicating with your son, since you've been incarcerated, Mr. Boone has paid for that. Is that correct?
It's my only form of ability.
Ma'am,
right now,
answer
yes.
the question. Has what your communications with the child been paid for by Mr. Boone since you've been incarcerated?
Yes.
Okay.
Next question.
You have a $50 charge here for clothing. Does your prison provide you with clothing?
Yes. The prison provides uniform.
Okay. And then you have $15 here for medical and dental. Does the prison offer you any medical services?
You have to have a lien against your account. To make a sick call, you have to pay for that. For dental, you have to pay for that. Regardless if you have an insurance plan or not, you still have a lien placed against your account.
Okay. And you are estimating that your cost for that is $15 a month on your financial affidavit. Is that correct?
Yes.
Okay. And then you have here other hygiene and writing items. Does the prison provide you with basic hygiene items?
No. The prison only supplies I believe, 1.5 ounce all-in-one shampoo and body wash, toothbrush, and toothpaste.
Okay. Those would be considered hygiene items, correct?
Yes.
Okay. And you have here a $50 charge for creditor Department of Corrections. Are you indicating that you owe the Department of Corrections money?
These are all estimates. And you need to please remember that I am new to DOC and don't understand, but I do know that weekly draws from everyone's account every week. So depending on how much money you have in your account is how much they deduct from your account. This was just an estimate. I'm not even sure how they go by what they do, but this was what I was told to do from one of the classifications officers. And a lot of these, if you see at the bottom, it states estimates for all. The clothing is charged quarterly. It's not every month. And there's limited quantities, and also the prices fluctuate, which is why I included those as my exhibit so you all would understand the most current pricing.
Other than receiving contributions from third parties and receiving money from Mr. Boone, since you've been incarcerated, have you had to pay any money out of your own pocket to meet your day-to-day needs while you have been incarcerated?
Sir, I have no money.
I'm sorry, I didn't understand your answer. What did you say?
Sir, I have no money.
Okay. So the answer would be no, correct?
I have no way of doing so. No, I do not have any way of paying.
I have no further questions. Sir.
All right. Ms. Boone, I will give you an opportunity to talk about the financial affidavit in just a minute, but I'm going to ask counsel any additional witnesses.
No, Your Honor, I just have some reserve a little bit of time for closing argument.
All right, any additional evidence?
No, Your Honor, just some demonstrative aids that I'll be arguing in closing. Okay. So the answer would be no, correct?
I have no way of doing so. No, I do not have any way of paying.
I have no further questions, Your Honor.
All right. Ms. Boone, I will give you an opportunity to talk about the financial affidavit in just a minute, but I'm going to ask counsel any additional witnesses.
No, Your Honor, I just have some reserve a little bit of time for closing argument.
All right, any additional evidence?
No, Your Honor, just some demonstrative aids that I'll be arguing in closing.
All right, Mrs. Boone, Counsel has indicated that he has no additional witnesses or exhibits for this court to consider. I am now turning it over to you to present any evidence that you want this court to consider and any testimony you want this court to consider. And that includes any testimony or any explanation or additional testimony you want to provide to the court regarding your financial affidavit. Once you are done, counsel for petitioner will be able to ask you some cross-examination questions as well, okay?
Yes, Your Honor.
All right. And again, I'm going to say to you again, the topics we're here on today is the proposed parenting plan that was admitted into evidence as petitioner's exhibit number 1, that was pre-marked as G in the packet of materials that you received, as well as the request to have the alimony of $1,000 per month discontinued and the issue of child support of $100 per month discontinued and the request for attorney fees. Those are the only issues the court is considering today. Those are the only issues that you will be permitted to provide evidence on at this time. Okay?
Forgive me, it's Exhibit D, the proposed amended parenting plan, the attorney fees, and what was the last?
The request to discontinue alimony and the request to discontinue child support, which I think you said you agree that he should not be paying child support as of February of 2020.
Okay. So parenting plan, attorney fees, and alimony.
Correct.
Okay. So for the parenting plan, I would like please to put into evidence my number 2 and 3. I'm sorry. The parenting plan, the original one. My number 2.
All right, give me just a minute.
Where it's signed by both parties.
Counsel, do you have any objection to what Ms. Boone had pre-marked as Exhibit 2, which is the parenting plan that was filed with the court back on May 9th of 2018 coming into evidence?
No, Your Honor.
All right, hearing no objection, I'll receive us into evidence what was pre-marked as Respondent's Exhibit number 2 as Respondent's Exhibit number 2. All right, what was the second document?
The second document is the certificate of completion for the parenting and divorce class, my number 3 and 4.
For the record, I have here what Respondent marked as 3. It is a parenting class certificate that was filed back on April 24th of 2018, and which is pre-marked as 4, is the parenting plan certificate filed back on May 15th of 2018. Any objection to Exhibits 3 and 4?
No.
All right, I'll receive into evidence what was pre-marked as 3 as Respondent's Exhibit number 3 and what was pre-marked as 4 as Respondent's Exhibit number 4. right. What's next, Ms. Boone?
Am I allowed to explain those?
All right, I don't know that any explanation is necessary, but go ahead.
In regards to the parenting plan, first and foremost, I would like to state that one moment. From my parenting or from my pretrial statement, please, I would like to say that my incarceration has nothing to do with me as being a human being and a mother to my son. I've done everything I possibly can to be a part of his life, regardless. And with the active parenting plan, my former husband has excluded me from my son's life in every way, shape, and form and alienated me, which is not part of the active parenting plan. So since 2020 of my incarceration to the present date without any modifications, he has followed the parenting plan in regards to trying to encourage the relationship as discourage the relationship. The point of my certificates of completion are to show the different topics that were covered in the court-ordered class that he had the understanding that he was supposed to abide by in regards to acting appropriate towards the other parents in front of the child, which he has not done. And the burden of proof is on the opposing party to show unfitness, and I shouldn't have to prove my worthiness. And I've done everything I possibly can in regards to be a part of my son's life. And as you heard the petitioner himself say, he doesn't care. He does not answer my phone calls. He does not answer my tablet messages. He does not respond to my letters. He's not made any attempt to find out any contact information. He's not done anything in regards to have me be a part of my son's life, and is now going from having me speak to my son on an almost regular basis down to one 30-minute phone call. I believe that is more detrimental to my son as opposed to helping him when I have had my parental rights intact since day one of my incarceration, and have helped my son since the day he has been born. And I don't believe that they should be terminated, or a 30-minute phone call should be viable, because no alternative exists. My parental rights should not be taken away. That could just be a last resort, and I don't know why he's doing it, and I am used to him saying he doesn't care. And I believe that my rights should be preserved, and I have all of my case laws stating such. So I don't know what I'm supposed to state that, or if this is my opportunity. I don't know what I'm supposed to do.
Do you find yourself kind of zoning out when you listen to her scratchy voice, her whining? I need to be in the part of my son's life since he was born, and I don't even know what to do here, Judge. Please forgive me. Ugh.
The minor child is very aware of these ongoing hindrances and speaks about to the respondent and his desire to see her in person, which she also has been asking petitioner about almost on a daily basis. The minor child apologizes to the respondent regularly that the petitioner does not do and prolongs their overdue time together in person. The multiple children's rights he has violated in regard to developing an independent and meaningful relationship with each parent because of the petitioner. He is present during the parents' personal battles while I'm trying to speak to him on the phone. To speak ill will, he has called me murderer and killer in front of my son, which is another reason why I wanted to have a guardian ad litem, which has been denied, I believe, 3 times. It doesn't include me in any way, shape, or form in regards to anything that has to do with my son's life. I know a lot about my son. I know what his favorite color is. I don't believe that petitioner even knows that. The name of his girlfriend, the things that they're going through. I am part of his daily life. And for him to take that away from me is just out of bitterness and spite. I want to be a part of my son's life.
You know his favorite color? Well, I sure hope so. You know who his girlfriend is? Well, he probably told you. Sarah, you have to realize you are in prison now. And you're never going to be able to be a part of your son's life like you were before you put George in that suitcase. You've not only murdered George and obviously gotten yourself life in prison, but you have caused upset not only for George's family, but your own. Your ex-husband, and most of the problem is your child. He is going to never forget what he's been put through from this experience. And yeah, I realize that he's still 14. For the next few years, he's got to abide by what the court states. But I feel like you should give him some space. And maybe when he's a bit older, maybe he would be more interested in some sort of relationship with his mother. But, even if he's forced to visit you 12 times a year and, have phone calls, you're not going to make, those are not going to make him love you. It's got to be genuine. And like I said, you've done a lot of harm to him. And, obviously, you don't get that right now, but I do hope you do someday. I really do.
And people forget that I have a pending appeal. So to prove my innocence, which is what I've been doing since day one, the reason why I was incarcerated in Orange County for over 5 years, or at least 5 years, was because I continued to fight for my case. I know that the petitioner understands the reasons why of the enclosed 30% time sharing because of the danger and safety. There's a lot of things that I was trying to protect my son from. I'm not that parent because I was trying to make sure he was safe and in a safe place. The time sharing is, of course, it makes no sense to have the realization one is not what we're talking about now. I do not feel that it is right for me to have a 30-minute phone call with my son when I'm trying to do everything that I can to be in his life in every way, shape, and form that I possibly can, from having people in Australia purchase him a record. Anything that I can possibly do to go out of my way to do, I've been doing for him. So he remembers and knows that I am in his life and I am his mother. And I am doing everything I possibly can to stay that way, regardless of the petitioner and his counsel's attempts to deter me from being part of that. I try to communicate with the petitioner in regards to my son. I've been continuously excluded. There is no communication. I don't know what else it is that I can possibly do that I haven't tried to already. And a lot of these, too, I would like to remind everyone, these could have been solidified would they have had the meeting of attorneys and unrepresented parties meeting. A lot of this could have been had and resolved and narrowed if we were to have had that meeting in regards to all of this. Nonetheless, if the petitioner would have answered a phone call or a comment message, it's not fair to me that just because I'm here, it doesn't justify how I've been treated and excluded.
Whoa. Okay. First off, I like how she thinks she's going to get an appeal for her murder trial, for her murder case. Good luck with that, Sarah. Also, note the looks on the judge. She looks really, really thrilled by this yammering coming out of Sarah's mouth. It's not fair to me Well, it's not fair to George's children, George's family, that you took his life. It's not fair to your son that you have put him through all of this. And now his mother, the one who gave birth to him, is, found guilty and in prison because she was guilty of murder. And it's not fair to your brother, and it's not fair to your ex-husband, Brian, the petitioner, that you've had to put them through all this. So if you think it's not fair, you really need to step back and see how unfair life is because of your actions.
With it, I would like to continue to have the regular phone calls and interaction with my son, which I have been doing, and all of a sudden now is being tried to be taken away from me out of sight, as opposed to my son and his growth and him moving properly and appropriately and lovingly forward with his mother. And I would very much like, please, after 9 months of asking for my son to please come see me, which is only 50 minutes away, which I think will change both of our lives with finally being able to see. I don't know if you can hear me, but there's incredible feedback. Static.
All right, we can hear you. You can continue.
I would like, from the parenting plan, my resolution, please. If I need to, I don't know what I'm supposed to do if I say it again. If that's on record from previous, but the daily telephone calls, personal space for him to grow up as the teenager that he is. He's going to be a legal adult in 3 years, which is why I'm unclear on why he's fighting for this. So the petitioner, nonetheless, I've not been included in anything major or included in an ending period since day one. So I don't understand. But I would like to have, please, tablet messages, all the features, everything that I can possibly have still, please, to be in my son's life. This is another reason why, too, that I was trying and adamant to have a guardian ad litem appointed. And I believe that I would like to suggest that some type of co-parenting course or counseling in regards to how to treat the other parent, which he has already taken, but back in 2018 upon our original divorce. So he can be reminded, please, on how to treat the other parent and also look out for our son's emotional distress that he has been causing him by calling me names and not speaking to me and giving me the silent treatment when I'm trying to speak to him solely in regards to my son. I'm doing everything that I possibly can for my son. I've been avidly striving to and will continue my pursuit to be even more meaningful to my son in my continued hard-fought efforts to see him in person while temporarily located at DOC and in the meantime of my appeal and my release and all other positive aspects that I have with my son on the horizon. I've encouraged him, acknowledged him, understood him, listened to him, believed in him, and I make him stronger and more beautiful. Foremost and above all, meaningful means love, which the respondent ceaselessly and immeasurably will always have a wholeheartedly provide for her son, which is priceless, and no circumstance or agreement or modification in any lifetime can change or end. I'm hoping that the court can see my ceaseless attempt and whatever it is that I can do in order to stay in my son's life for longer than 30 minutes per week, please. I have a lot to offer and I can help him grow in multiple ways. And I am his mother, and I wish that I had the guardian ad litem or my son to be included in this, which, if I can also include, please, into evidence my It's the notice of filing the respondent's answer to the supplemental petition for modification of final judgment, which is number 7, please.
Give us just a minute. All right. So what I have before me is it looks like petitioner filed a handwritten document on it's dated May 1st of 2022, but it looks like it was filed with the court on May 16th, and there was a notice of filing by Attorney Martell. Looks like he may have received a copy of it and he filed it with the court. Is that?
Let me just pull it up, Your Honor. I'm sorry.
It's okay. But I am seeing it both in the court file on May 16th of.
Is it an answer to our?
Yes, and it looks like you may have filed a notice of filing just to make sure it got into the
Yeah,
court.
I no objection.
All right, so I'm going to receive what is presented as Respondent's Composite Exhibit 7, which is that notice of filing by Attorney Martell, as well as the actual handwritten answer. I'm going to receive that into evidence as Respondent's Exhibit number 5. All right, Ms. Boone, you may continue.
This was just me trying to be transparent with the petitioner's counsel and describing to them my need and want to be in my son's life back in 2022. Explaining my dedication and my decisions and ideas and opinions, they matter. One obscure enforcement incident does not define me as a person or my entire existence. And I'm trying to be my son's best advocate for myself. And 2 parents are involved. Just because I'm not there under the same roof to make the same decision, or at least I would like to be conferred with and included on so I know what's going on in the son's life. This is just me trying to know what is going on and to let them know what I'm striving for, that there comes to some type of cooperation or collaboration. This was just me emphasizing to them that I very much would still like to be in my son's life. That is my letter originally in answer to their modification of this final judgment, which we are in the process of debating. For also the parenting plan, which is still active, the original from 2018, I believe, I wanted to bring to the court's attention that it's been violated by the petitioner. Again, from previously, now I believe it's the time where it says the parenting plan may be modified or verified on a temporary basis when both parents agree in writing.
All right, Ms. Boone, Ms. Boone, you have to agree that there's a lot that's not being followed with regard to that parenting plan, which includes even the time sharing that you're not able to do at this time.
Right.
You would agree with that, correct?
I understand that, but that is my only stipulation. That's my only part
Okay.
that
All right,
I'm
you would
unable to
also
apply-
agree that that parenting plan was entered into back in 2018 prior to there being any criminal charges in your incarceration. Do you agree with that?
I do, Your Honor. But it
Okay,
was
and you
still
have to
an-
also agree that when the parenting plan was entered into, if I remember correctly, you all agreed to the parenting plan as part of your mediated settlement agreement back in 2018. And at that time, neither one of you were contemplating any type of criminal charges or incarceration. Is that correct?
Yes, Your Honor.
Okay. All right, you may continue.
So I was would like to bring in the part of the divorce certificate, which includes each parent and everything they're supposed to abide by regarding being appropriate to the other parent, regardless of incarceration or not. That's what I was trying to say. I've been excluded this entire time, and everyone has blamed my incarceration on it, which it shouldn't be like that because I'm still the mother of my son regardless of where I am. And what petitioner has been saying and doing and not doing are unacceptable and to a certain extent unlawful, especially with the active parenting plan. It shouldn't be done anyway, with trying to hinder my relationship with my son. There's no reason for him to do that. And again,
So Judge Jackson tried, the judge tried to maybe reason's not the right word. She tried to say, well, you were not in jail, in prison in 2018. The bottom line is you can't have the same kind of contact and have the same arrangement that you had back in 2018 in regards to a parenting plan when you are in prison, Sarah. It just doesn't work.
in conclusion, the continuation of his responses, I don't care. That's what I've gotten since I've been here. So do I bring case law up right now, or is that something I could?
All right, if you'd like to bring up case law, you can.
Okay. So, I'm looking. Excuse me. Thank you for your patience. Children. Okay. In regards to children in the parenting plan, Hunter versus Hunter, the court ruled that incarceration in and of itself is insufficient to terminate or deny custodial rights unless continued contact is shown harmful or detrimental to the child.
All right, give me the case name again.
Hunter v. Hunter.
All right, do you have a case citation?
Yes, Your
The
Honor.
number, okay, give that to me.
540 S as in Sam, O, 2, D as in dog, 235, in parentheses, SLA, 3, D as in dog, DTA, 1989, in parentheses.
189.
Yes, 1989.
All right, you may continue.
Thank you, Your Honor. Also for that case law, the court has discretion to restrict visitation only to protect the child. The petitioner penalizes the respondent for her incarceration. Also, it reinforces that inability to communicate, not incarceration, is the key benchmark for limiting shared parenting. I have multiple ways of trying to communicate with my son. And I've been trying every single one and trying to share parenting as best as I possibly can while located here. In fact versus fact,
I'm sorry, were you done or are you looking for your
oh no,
next topic?
forgive me. I was reading another case law to you.
All right, I have the Hunter case. I've gotten that. Do you have another case?
Yes, I do, Your Honor.
All right,
Please.
all right, hold on, give me just 1 minute.
Thank you for your patience.
All right, your next case?
Ogilvy, Ogilv, V as in Victor, IE.
All right, just give me the citation for now.
Forgive me, 2007 FL 2D DCA. Ogilvy versus Ogilvy.
All right, you may have to give me the spelling of the name again. Go ahead, OG.
ILVIE.
V as in Victor.
Yes, Your Honor. This holds
Right.
that
Jennifer, hold on. Jennifer Ogilvy versus Dale Dean Ogilvy.
I don't have their first names, Your Honor. I just have Ogilvy versus Ogilvy.
All right, well, the case citation you gave me is not a formal case citation, so I have to figure out if I have the right case here.
If I
All
may,
right, go ahead and tell me your position on what you believe the case states.
it holds that parental alienation taxes, like disparaging the other parent or withholding visits, constitute interference and harm for the child. I have limited resources at the law library, so forgive me.
No, you're fine. I just need to make sure that I have the right case and I believe I do.
And then I have another one after that that has the same type
All right.
of.
Give me just a minute. All right, counsel, for the record, the court has found the Ogilvy case that I believe she is referring to, which is 954 Southern 2nd 698.
Yeah, I got it here too.
Which is a first DCA opinion in 2007.
Okay.
All right, your next case?
Lobria, it's LOGREIRA versus Lobria. I don't know if I'm saying that name right. Sorry.
All right, is that 322 Southern 3rd 155. Do you have that?
All I have, Your Honor, is 2021 third DCA.
All right, for council, I have that as 322 Southern 3rd 155, Florida 3rd DCA, June 2nd of 2021.
Got it. Thank you.
I'm sorry.
No, you're doing fine. We just have to locate it based on what you're saying, and I just want to make sure that I have the correct case, okay?
Thank you.
So give me just a minute. I believe I found it, and I just need to make sure that I give counsel the citation that I'm looking at. So that's why it's taken a little bit of time, just so that he's on the same page, that he's looking at the same thing the court is looking at.
Yes, Your Honor, thank you.
All right, and why do you want the court to consider this LaGuerra case?
Any restrictions must be court ordered based on evidence and accompanied by a fair hearing. Unilateral actions are ineffective and wrongful. It also emphasizes the need for due process before suspending parenting time. I have two more after that, and I'm complete with it.
All right, give me just a minute. All right, the next case you have?
Thank you. Perez, Perez versus Perez. And I have a citing.
Okay, give me the citation.
769 SO2D 389 parentheses FLA 3D DCA 2000 in parentheses.
All right, that was 760.
No, 769
760. All right.
did you
For
need the
counsel,
summary
the court,
part?
hold on a minute, ma'am, hold on. For counsel, the court has found the Deborah Perez versus Jorge M. Perez case at 769 Southern 2nd, 389, Florida 3rd DCA, 1999.
I found it.
Hold on 1 minute, ma'am. All right, why do you want the court to consider the Perez case?
Because this underscores that restrictions on parenting time must serve the child's best interest, not a parent's convenience, retaliation, or preference. Also, courts require proper legal process and evidence, not unilateral actions to alter the parenting plan's time sharing term, regardless of where the parents are located.
Hold on just 1 minute. All right, you may continue.
Yes, please. If I could please add one more. I have two more and then I'm complete.
All right, go ahead.
Thank you. It's just stated as in regard to adoption of children by LAS, and the citation is 650, capital A is in apple, 2D, 214, in parentheses, 1994.
All right, that was 650A2D202.
214.
Counsel, have you had a,
I couldn't figure find
yeah,
it.
we cannot find that case.
Yes, please, if I could put a substitution in,
If you can do what?
may I substitute one for that? I have another one
Okay.
in place of.
Okay,
If I could just give you the citation,
yes, that's fine.
it's 996 SO2D 930 parentheses SLA 2D DCA 2008 in parentheses.
Counsel, the court has found RE versus Department of Children and Families at 996 Southern 2nd, 929, Florida 4th DCA opinion from 2008.
Got it.
All right, and why do you want the court to consider this case?
Thank you, Your Honor. The court found that incarceration alone is not ground for termination of parental rights, and they still have the right to raise, contact, and participate in their child's life unless proven unfit on other grounds. And one more.
Before
and I'm
you
done.
continue, hold on, before you continue, I have not heard any arguments or evidence that anybody's trying to terminate your rights. That's my understanding. That's not what's happening here. Is that correct?
Yeah, this is not a TPR proceeding. Yeah.
Got it. All right.
Hello?
All right. You said you have another case? All right, just, oh, actually, hold on. Before you go, Ms. Boone, one of the, I don't know if you heard the court wanted clarification from counsel for petitioner. Based on everything that I've read and the testimony that I've heard here today, this is not an action to terminate your parental rights. Counsel confirmed for me that that is not what petitioner is seeking in this case. Okay, now you can go ahead with your next case.
Yes, please, if I may comment on that. It is in regards to me speaking to my son one day a week for 30 minutes, and
That
that's
is
what I'm trying
not
to.
terminate. I understand that, ma'am. What I'm saying to you is the case, and the court does understand, and there is a distinction between terminating parental rights and requesting a specific parental responsibility. So, this case is not about terminating your parental rights. And the court is not considering a request to terminate your parental rights, but you can continue with your next case.
Okay, I'm just trying to clarify what my parental rights are. Spec v. Spec, SPECK. The citation is 225 SO 3D 319 parentheses SLA 3D DCA 2017.
So it's Brown versus State.
Spec v. Spec.
Okay, I need a citation one more time. I'm sorry.
Sure. 225 SO 3D 319 parentheses SLA 3D
All right, the court is not finding a Feck versus Feck case. That is a citation for Brown versus State, which is a 2017 opinion regarding waiver of appeal arguments dealing with a sentencing order.
Okay, one moment, please, if I may. I'm looking through really quick. Okay. I'm just trying to locate. Okay, Your Honor, forgive me, that's what I have for that one.
I'm sorry?
Okay. That's the 225, that's what I have for that, which apparently is
All right.
not right.
All right, any additional cases?
No, Your Honor,
All right,
for that, no.
all right. Any additional?
That was very, very, very painful, guys. And thank God it's over.
Additional evidence you want the court to consider?
In regard to the parenting plan,
In regards to any of the issues that we're here on today that I have recited over and over, I think I might be on time number 7 now.
in regard to the alimony, I would like please to add case law.
Okay?
Florida statute 61.14, I believe.
All right, repeat it for me. I'm sorry.
Just one moment. I'm trying to make sure that I have everything pulled up. Okay, I'm going to start, please. Would you like to have the citation?
Yes.
39 SO 3D 453 SLA 2D DCA 2010.
right, is that Malik versus Malik?
Grigsby versus Grigsby.
Say the citation for me once again.
39SO3D453.
Okay, now say the name of the case for me.
Grigsby, Grigsby.
Got it.
Not have to do with alimony.
All right, the court has found Grisby versus Grisby at 39 Southern 3rd, 453, which is a second DCA case from 2010. Dealing with the issues on sole parental responsibility, reestablishing time sharing.
This, I believe, was in regards to alimony.
It is not regarding alimony. All right, give me just a minute. We're going to have to go off the record for just a minute. We're going to take like a 3 to 5 minute break.
Okay.
My laptop, because something happened about 4 or 5 months ago, it only charges with a specific charger. And so my computer is telling me it's about to die. So my judicial assistant is running up to grab a charger that's actually going to charge my laptop so it doesn't die. Okay?
No problem.
And I do apologize for that. But meanwhile, I am going to make sure I save my notes so that they don't disappear. If my computer should all of a sudden go completely out. Ms. Boone?
Yes, Your Honor, I'm here.
Okay, all right. I don't know if you were able to hear me earlier. Just so you know what's happening in the courtroom, I am in a different courtroom today. And even though my laptop has been plugged in to allow me to see on a separate screen, it was not charging due to an issue with my laptop that happened about 3 or 4 months ago. So now we have a charger for my laptop. I am back up and I am ready to take your next case citation regarding alimony.
Yes, Your Honor, thank you very much. My next is Bowen, Bowen versus Bowen. And the citation 471 SO 2D 1274 SLA 1985.
All right, give me the number after the 2D.
1274.
Got it.
Parentheses.
Okay.
Okay.
All right, for counsel, I have the Bowen versus Bowen case, 471 Southern 2nd, 1214, Florida Supreme Court, 1985.
I've got it. Thank you.
All right, go ahead, Ms. Boone.
Arrearages and alimony are vested rights and enforceable. While the court-ordered alimony period has now ended, the expiration of that period does not erase arrears that accrued while the order was active. Florida law is clear that past due alimony becomes a vested right, and the obligor remains responsible for payment regardless of whether the alimony term has since expired.
All right, anything else?
Yes, I have, the citation is 418 SO2D 1113. It's Florida, 5th, DPA, 1982.
And what's the case name?
Lamb versus Lamb.
All right, that was 418.
SO2D, 1113.
All right, 418 Southern 2nd 213.
2D, 1113. So 1113.
I'm not seeing that one. That site.
All right, give me the full site. Start with the first numbers again.
418.
418 SO2D
1113. In parentheses, Florida, 5th, 5th, DCA,
The court does not
1982.
find the Lamb case at this citation. 418 Southern 2nd, or do you say 2D or 3D?
2.
All right, that is not a citation for a case named Lamb.
Lamb versus Lamb.
All right, and I need you, how many more of these you have? We were down in 15 minutes and I gotta give counsel an opportunity to question you and then save time for closing arguments.
I'm not sure. That's why being on the phone is very difficult. I'm sorry. I'm doing everything that I possibly can to properly represent myself. Let's see. Lamb versus Lamb is not Bowen versus Bowen. Tindall, Tindall.
All right, give me the citation.
It's not on here. Forgive me. They did give it to me. When?
All right, without a citation, the court cannot find a next case.
I'm sorry. My classifications department is speaking to me. Hold on one moment, please. I'm sorry.
Hello, excuse me. Your Honor. Hello, Your Honor.
Yes.
This is Classification Officer Santiago. I work at Lowell Correctional Institution. Due to our procedural operations over here, she's going to need to be off the phone at 4:50 in 5 minutes. And I just thought that I would come on here and let you know.
Your Honor,
And
may.
then, and then
Okay.
also, for future court appearances, they are requesting that communications go through the classification officer so that we can make sure that she has plenty of time to complete all of this so that we're not having to rush her off the phone.
Right. Information was sent regarding this final hearing. And we, my office has been in contact with the Department of Corrections for quite some time over the last couple of months trying to get this set up because we had initially requested that she be transported to Orlando for this hearing. So there has been contact. All right, but right now you are slowing us down and trying to get this finished, so give me just a minute. Hold on. Yes, counsel.
Your Honor, what I would suggest, I have no other questions for Ms. Boone. So what I would suggest is that perhaps the court allow both me and Ms. Boone to have a certain amount of days, not a super long amount of days, but a certain amount of days to provide written closing arguments to the court, and then the court can take the case under advisement and make a ruling, so we can get this done today.
All right. All right, so what the court is going to do is we're going to go ahead and finish up, I believe. Other than case law, Ms. Boone, did you have any other evidence that you wanted the court to consider?
Yes, I did. I had some other exhibits that I would like to have put into my evidence, and then I also was supposed to speak about the attorney's fees.
I've given you lots of time to speak about all the issues. The fact that you didn't take that opportunity instead of going into other issues is not what the court is going to address now. What specific exhibits do you would like to move into evidence?
Your Honor, forgive me, but I'm here on the phone
Forgive
trying to do
me
all
when
of
I
this.
ask you what other exhibits that you want to put into evidence.
My number 10, respondents' correspondence. I'm sorry, number 9, respondents. Motion for contempt.
All right, I'm not considering a motion for contempt with regard to a final hearing. Okay? Anything else?
It was my understanding it was held in continuance until this actual moment, which is why it's been waiting to be heard.
I think she's referencing, Your Honor, the motion for contempt on the non-payment of alimony, not the most recent motion for contempt that she filed.
Okay.
Yes,
Yeah.
this was
All right,
done,
the court will
and
take judicial notice that you have filed a motion for contempt with regard to the alimony. Okay? And that
And
is
that was back in
something that
2023.
that is something that I am considering because I've got to deal with what the alimony that was not paid, okay?
yes, Your
All
Honor.
right, so with that
I'm not-
clarification from counsel, I will take judicial notice of your motion for contempt with regard to the alimony.
Okay, and then also the petitioner's account statements, which is my number 15.
Okay.
Counsel, this looks like truest bank statements.
Okay. We gave it to us in discovery. Yeah. No objection, Your Honor.
All right, hearing no objection, I'll receive into evidence what was pre-marked as 15 as respondents exhibit number 6.
Yes, Your Honor. And then number 21 through 25. Respondents, correspondence to judge regarding non-payment of alimony, parental alienation, and requests for case management conferences.
Very good. All right. These are filings within the court. The court does not need to receive this as evidence.
Okay, if I may ask for judicial notice.
All right, the court will take judicial notice of documents that were filed on October 18th, 2022. January 31st, 2023.
There should be 5.
February 22nd, 2023. I do not see a filing date with regard to number 21.
They should be 2022 through 2023.
For the record, counsel, Exhibit 20 is a notice of filing prepared by yourself. Looks like, again, filing some documents that you received. I think, oh no, this is notice for trial for 20. All right.
I'm going through it well.
All right, so also court's going to take judicial notice of the notice for trial filed on, August 17th.
That's not part of my evidence. You may have gone one too far.
You just told me 21 through 23. All right, so that's 20, so we don't need that one. All right.
21 is respondent. 22 is
All right.
respondent.
Exhibit number 24 is not indicating that I don't see anything on it that it was filed with the court, but it is a,
It was probably cut off from the copies that I had to obtain.
all right, the
Some
court
of
does
them
not
are-
need to take judicial notice of a request for case management conference, so the court will not take judicial notice. Anything else?
It's trying to show my exclusion in the case.
The court has ruled I am not taking judicial notice of a request for a case management conference. Anything else?
Number 27, 28, and 29.
All right, 27, it looks like it's a letter dated March 2nd of 2023 to Attorney Martell. Any objection to this?
If it's a letter to me, it's self-serving hearsay, so I would object.
All right, I'm gonna sustain the objection as to exhibit number 27. I have a November 26, 2024 letter addressed to Attorney Joshua Martell as exhibit 28. Any objection?
Same objection, Your Honor.
Sustained. Number 29. Appears to be handwritten letter to Brian dated May 12th of 2024. Marked as exhibit number 29.
Same objection, Your Honor.
All right, sustained. All right, anything else?
Number 31. Respondents, witnesses, letter.
So letter to whom it may concern.
These are my character witness letters.
It's your what letter? I'm sorry?
Character witness letters.
Objection hearsay.
Sustained. Next.
Number 32.
Number 32. Current judgment interest rates.
Those are in regards to
No.
alimony arrears.
If it's just reciting the statutory interest rates, no objection, Your Honor.
You review the document?
Let me see.
You object or you don't? Deputy, you could hand him this.
I haven't seen any of these exhibits, Your Honor. My apologies. No objection.
All right, hearing no objection, I'll receive into evidence what was pre-marked as 32 as respondents exhibit number 7. All right, anything else?
Number 35. I've got one more. And number 37. They're telling me I have to go.
All right, number 35, you can approach counsel.
Okay, thank you.
Looks like something dealing with the canteen.
It's the canteen items with current pricing. That's for snacks for medical reasons.
All right, hearing no objection, I'll receive into evidence what was marked as number 35 as number 8 and what was marked as number 37 as respondents number 9.
The JK communication features and current pricing.
All right, next.
The number 37, which is JK communication features.
We
and
already
current
admitted that
pricing.
into evidence as exhibit number 9. Next.
Okay. And you have the GCL communication?
I have no idea what that is. If you, next piece of evidence that you want to, next exhibit that you want to admit into evidence. Anything else?
I think we're missing one because I'm going to put in the JK communication. I put in the GCL communication, but not the JK.
We have number 35 admitted into evidence as number 8, number 37 admitted into evidence as number 9. Next.
Number 36.
Would you like me to look at this, Your Honor?
You can stay up. All right, we're receiving to evidence what was pre-marked as 36 as respondents exhibit number 10. Which is also
Yes,
a
Your Honor.
J letter. Next.
That's all I have for right now, Your Honor. I'm being rushed out.
All right, I'm gonna give you all until next Monday at 5. I'm gonna say by 5 p.m. That includes, Ms. Boone, you need to put it in the mail by next Monday, a written closing argument on the issues we're here on today, okay? So I'm gonna give you all until 1 week to provide written closing arguments, no more than 5 pages.
No more than 5 pages.
That is correct.
Parenting plan, alimony, attorney's fees.
Counsel.
Can I submit real quick 2 exhibits before we end?
All right, what are they?
I just have, these are more for demonstrative purposes, but I have my proposed child support guidelines worksheet that was marked for identification purposes as petitioner's B, and then my case law, which is in hard copy form marked for identification purposes as exhibit C. This is all
Or what was the child support guidelines? What was it pre-marked as?
B.
B as in boy, and then the case law as C.
C.
All right. Ms. Boone, do you have any objection to what was pre-marked as petitioner's exhibit B or C, the child support guidelines or case law?
No, if someone explains it to me though, if we have a chance to, I don't understand it.
All right, hearing no objection, I'll receive into evidence what was pre-marked as B as petitioner's number 4 and what was pre-marked as C as petitioner's number 5.
Please, if I may, before we hang up, the closing arguments are for parenting plan, alimony, attorney's fees, and
I am not
Really?
repeating myself, ma'am. You need to make a closing statement. You need to put it in the mail to me no later than next Monday, which I believe, actually, that's a holiday. So I'm going to give you all till Tuesday, which is September 2nd. I will not accept anything that is postmarked beyond September 2nd. Again, this is closing arguments on the issues we're here on in trial today. No more than 5 pages. Thank you and have a great day.
Oh boy. All right, I did my best to not cut in toward the end there, and I'm playing a little editing game in between. But that was very, very, very painful, you guys. And we have to remember that the judge said postmarked by September 2nd at 5 p.m. So I could tell you I'm finishing this recording on Tuesday evening, and it's not going to get up until some point tomorrow, September 3rd. And again, I appreciate everybody, all the comments. I love reading everybody's comments. So I'm going to think that, I believe, excuse me, if I can get my English out of my mouth correctly, it's probably not going to have a decision until maybe Thursday, Friday. We all know how the United States Postal Service works, and this is coming, if her closing arguments, which she's like 5 pages. Yes, Sarah, you can't write a book. So if it went in the mail today from Ocala, Lowell, maybe the judge will get it tomorrow or the next day. So we may not even have a decision until next week. I mean, that's possible. So I know I've been checking the docket, for the family court, and I'm sure a lot of you guys have. So as soon as I see an update, I am going to still keep checking it daily. But I will let you guys know. I probably won't do a video just on that, so please make sure you are subscribed if you're not already, because I will be putting it up on my community tab. And of note, I did open up the community for you guys to post if you have questions, obviously about Sarah Boone in this case, or if you want me to cover a different case, please feel free to make your comments there. It has been a long day. It's like a Monday on a Tuesday. But with that said, I hope you guys have a great rest of the day, and most of all, stay safe.